Welcome to our overview of Chapter 8, Disability Law. Disability is a natural part of the human experience, occurring worldwide throughout the human population. It is estimated that 10% of humans have a disability, making persons with disabilities the largest minority group in the world. The treatment of persons with disabilities, however, has been among the darkest chapters in human history, with almost unspeakable abuses occurring. Historically, babies born with disabilities were left to die. Those who survived were often locked away under deplorable circumstances, abused, forcibly sterilized, lobotomized, and treated as expendable. Persons with disabilities were among the earliest victims of the Holocaust. By 1941, more than 10,000 disabled persons had been killed by the Nazis through starvation, lethal injection, or gassing. Even in the U.S., there is a shocking history of using disabled persons for unconscionable medical experiments, including, for example, intentionally injecting them with dangerous or fatal pathogens and carcinogens and feeding mentally disabled children radioactive cereal. The rights of persons with disabilities were treated as non-existent, including their rights to education. Today, however, there is common recognition of the evils of these practices and an expanding recognition that integrating persons with disabilities into the mainstream of society is both a moral imperative and a wise policy choice. Our common humanity requires that we recognize all persons' human rights as equal members of society and respect their inalienable rights to life, liberty, and the pursuit of happiness. Impairment of an individual's physical or mental abilities in no way diminishes the individual's fundamental human rights. There is a fundamental human right for every person to have an opportunity to participate in and contribute to society. With appropriate educational services, children with disabilities, like all children, can be prepared to lead productive, independent adult lives to the maximum extent possible. Appropriate educational services help persons with disabilities to become more independent and to develop their personal strengths and talents, reducing future costs and improving everyone's quality of life. As persons with disabilities are better integrated into mainstream society, including the workforce, they are able to offer their unique skills and contribute to the economy and the common good. Prior to passage of laws protecting children with disabilities, these children were commonly excluded from public schools or did not receive appropriate educational services. Many believe that children who could not conform to common physical and cognitive standards did not belong in regular public schools with their non-disabled peers. The burden of educating children with disabilities remained primarily with their families, who often lacked sufficient resources to provide appropriate educational services. Educational services that were available to these children were often provided in segregated facilities, preventing them from interacting with their non-disabled peers. Following the court's mandate to racially desegregate schools in Brown v. Board of Education, advocates for children with disabilities championed integrating education for children with disabilities also. Based on legal theories rooted in Brown, dozens of cases were filed nationwide arguing that children with disabilities were being unconstitutionally excluded from public schools through a systemic denial of equal protection and due process rights. Two of these cases, Park v. Pennsylvania and Mills v. Board of Education, resulted in landmark decisions recognizing educational rights for children with disabilities. In Park, a federal district court held that mentally impaired students ages 6 through 21 should be provided with access to a free public education and should be placed in regular classrooms when possible or in special classes when necessary. In Mills, a federal district court expanded this doctrine to all school-age children with disabilities, holding that they must be provided with a free and adequate public education. The U.S. Congress was also working to address these concerns through appropriate legislation. In 1973, Congress passed Section 504 of the Rehabilitation Act, prohibiting discrimination against handicapped persons in programs receiving federal funds. In 1975, Congress passed Public Law 94-142, the Education for All Handicapped Children Act, mandating significant new substantive legal rights and procedural protections for handicapped children. The Act was renamed the Individuals with Disabilities Education Act, or IDEA, in 1990, with the addition of some important substantive changes such as provisions for transition services and changes in terminology, including the change from handicapped children to children with disabilities. In 1990, Congress also passed the Americans with Disabilities Act, or the ADA. The ADA extended anti-discrimination protections similar to those provided by Section 504 for persons in public institutions to many private sector areas as well. Although case law plays an important role in interpreting and clarifying disability laws, the law in this area is largely defined by federal statutes and regulations. These principally include the IDEA, Section 504, and the ADA. The IDEA requires public schools to provide a free, appropriate public education and related services for all eligible students with disabilities. This is a critically important mission, but implementation of the IDEA is also very complex and expensive. In contrast, Section 504 and the ADA generally only require non-discrimination and the provision of reasonable accommodations. Section 504 requires reasonable accommodations when they are necessary to allow persons with disabilities to participate in programs receiving federal funding. The ADA extends Section 504-like protections to the private sector in employment, public accommodations, transportation, or telecommunications. With Section 504 and the ADA, Congress intended to cover large numbers of persons, children and adults, potentially including any person with a physical or mental disability that substantially limits a major life activity, including caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Because the scope of who is potentially covered under Section 504 and the ADA is so broad, the scope of what is provided is necessarily limited in recognition of finite resources. While Section 504 and the ADA cover a broad range of the population, what is provided is fundamentally a right to non-discrimination and to the provision of a reasonable accommodation when necessary for the participation of a person with a disability. In contrast, in the IDEA, Congress recognized that some children would need vastly more resources to provide for their unmet educational needs due to the severity of their disabilities. For this reason, Congress limited who is covered under the IDEA to only those children who fit within 13 defined categories of eligibility, and who need special education and related services under the IDEA because of an eligible disability. What is provided for IDEA-eligible students may be extensive and expensive. IDEA-eligible students are guaranteed the right to a free, appropriate public education, required related services, and extensive due process protections, all of which can prove to be very expensive and administratively burdensome in some cases. Among these three laws, the IDEA has the most significant impact on public schools. Federal statutes, regulations, and judicial opinions concerning the IDEA form a complex system of legal rights and responsibilities. Schools are frequently involved in litigation concerning the IDEA. Accordingly, Chapter 8 focuses greater attention on the IDEA, including significant provisions from the current statutes and administrative regulations. In Chapter 8, we will review IDEA eligibility requirements, identification and evaluation of students, substantive educational rights, extended year services, the Individualized Education Program, or IEP, appropriate placements in the least restrictive environment, or LRE, placements in private schools, placement in private religious schools, related services, due process protections, discipline procedures, manifestation determinations, continuation of IEP services during removals, pre-qualification protections, transition services, termination of special education services, and making cost-based objections to requested IDEA services. We will also review Section 504 of the Rehabilitation Act, including protections for students, protections for employees, and the provisions of the Americans with Disabilities Act. In summary, concerning the IDEA, eligibility under the IDEA is based on a two-part test. One, whether the child has an eligible disability, and two, whether the child needs special education and related services because of that disability. The IDEA's child find provision creates an affirmative duty for school officials to identify children with disabilities. Children may be identified for IDEA testing through mass screenings for all children, or through referrals from parents, school personnel, medical personnel, or other persons. Parental consent is not required for mass screening tests administered to all children. But before individual evaluations for IDEA eligible can be conducted, school officials generally must obtain parental consent. Children eligible for IDEA services have a right to a free, appropriate public education, related services, and due process protections. Concerning what constitutes an appropriate education under special education laws, in Rowley, the court concluded that the basic floor of opportunity provided by the Act consists of access to specialized instruction and related services, which are individually designed to provide educational benefit to the handicapped child. Related services are those supportive services necessary for an IDEA-eligible child to benefit from special education. Under the Tatro test, health services must be provided as related services if 1. The supportive services are necessary for the child to benefit from special education, and 2. The services are not excluded as medical services that would require the services of a physician for other than diagnostic or evaluation purposes. Notice and hearing rights are provided throughout the special education process, from initial consideration of eligibility through completion of the special education program or a determination of ineligibility. The stay put provision requires that during the pendency of any change in placement proceedings, unless school officials and parents otherwise agree, the child shall remain in the then current educational placement. A disciplinary removal that constitutes a change in placement triggers IDEA due process protections, requiring the IEP team and other qualified personnel to conduct a review to determine whether the problem behavior is a manifestation of a disability. If the behavior is not a manifestation of a disability, school officials may discipline the student in the same manner that other students would be disciplined. Any removal for more than 10 consecutive days, however, constitutes a change in placement and triggers the procedural protections of the IDEA. If the behavior is a manifestation of the child's disability, the IEP team must implement a behavioral intervention plan. Discipline procedures under the IDEA may be among the most significant and the most confusing provisions for many educators and lawyers. Be certain and thoroughly review the summary of disciplinary options under the IDEA provided in Chapter 8. Transition services facilitate the child's transition from school to post-school activities and may include instruction, related services, community experiences, and the development of employment and adult living skills. Special education services terminate upon graduation with a regular high school diploma or age ineligibility. Concerning Section 504, Section 504 prohibits discrimination against any person who has a physical or mental disability which substantially limits one or more major life activities, has a record of disability, or is regarded as having a disability. Section 504 requires non-discrimination and reasonable accommodations. Individuals must be otherwise qualified, and fundamental alterations of programs are not required. An accommodation is not reasonable and therefore not required if it would result in unreasonable costs, administrative burdens, or health or safety risks. Persons may be excluded from activities if participation creates serious health or safety dangers, and no reasonable accommodation would effectively mitigate these dangers. But any medical exclusions must be based on medical data and medical opinions, and not mere speculation or irrational phobias. The ADA extended protections similar to Section 504 protections to many areas of the private sector. In conclusion, regarding close calls between the IDA and Section 504, to be eligible under the IDA, a student must meet minimum IDA qualifications. In close cases, however, erring on the side of the IDA may be prudent if it assures that the child will receive needed services, avoids contentious and expensive battles with parents, and forecloses future claims for compensatory damages. Regarding developing positive parental relationships and cooperation, parents properly play a central role under the IDA, but the IDA tends to be an advocacy-driven adversarial system. Parents that demand the most under the IDA often get the most. Further, the system for resolving disputes under the IDEA is adversarial and litigation-oriented, often aggravating rather than resolving tensions between parents and school officials. Litigation can make ongoing working relationships difficult and drain away resources that are needed to support education. In working with parents, it is easier to build good relationships than to fix broken ones. Developing a relationship of mutual trust and cooperation with parents early in the IDA process can be invaluable in effectively meeting the needs of IDA-eligible students without undue conflict or expense. Not all relationships will be positive and functional, but with appropriate efforts at building positive working relationships, less of them have to be negative and dysfunctional. Regarding dealing with a truly dangerous IDA-eligible student, in cases where parents refuse to cooperate with an appropriate change of placement and their child poses a genuine danger, safety must remain the first priority. School officials must take prompt, appropriate, and lawful actions to assure safety. Allowing a known danger to persist could lead to consequences far more serious than a due process hearing with parents over the LRE for their child, including tragic injury, death, and resulting tort suits. A truly dangerous student cannot be allowed to cause self-injury or injury to others when the danger was known and the injuries could have been prevented. The IDA does not require this result, and tort and criminal laws will not allow it. Regarding promoting a culture of respect and inclusion, tragically, children with disabilities are frequently misunderstood and dehumanized, too often becoming the targets of cruel bullying and abuse. Promoting a positive culture of respect, kindness, understanding, and inclusion in the school can help to reduce the frequency and severity of bullying and abuse of children with disabilities. Through leadership and educational efforts, school officials can help students to see special education students as friends and colleagues, and disabilities as a natural part of the human experience. With the development of mutual understanding and respect, special education students can become valued friends and not just the targets of misguided abuse and bullying. By including and respecting everyone, we make our schools better places for all. I hope you will enjoy your studies. Very best wishes.